Ever wondered what really holds our legal world together? You know, from those intense courtroom dramas you see on TV to the paperwork you sign when you buy a house? Well, it all comes down to some very specific, very carefully written documents. And today, we're going to demystify two of the big ones, pleadings and conveyancing. Let's get into it.
And just so you know where we're getting our information, our guide for this entire explainer is some great material from the Faculty of Law at the University of Delhi. So yeah, we're going straight to the source to get this right.
You know, this quote really gets to the heart of it all. At its most basic level, the whole point of law is to keep the peace. It's the system that's supposed to step in and peacefully figure things out when one person's claim of a right bumps up against another's. So, here's our game plan. We'll start with the big picture, the purpose of law and the two main kinds. Then we'll zoom in on pleadings, the courtroom story, and conveyancing, the property story. And we'll wrap it all up with the 4 fundamental rules that make a legal argument solid. Okay, first things first. Before we can talk about documents, we have to understand this major split in the legal world. Basically, every law you can think of falls into one of two buckets. You can think of it as the what versus the how. All right, so you've got substantive law. This is the what. It tells you what your rights are, what you're not allowed to do. Think of it like a recipe that lists all the ingredients. Then you have procedural law. This is the how. It lays out the step-by-step instructions for how to actually enforce those rights in court. You absolutely need both for the system to work. Now, let's get into our first type of document, pleadings. This is the absolute bedrock of the courtroom. It's the collection of formal, written arguments that give structure to pretty much every legal fight. So what does that actually mean? Well, simply put, this is how a legal battle officially begins on paper. The person who's suing files something called a plaint, which is their side of the story. Then the other person responds with a written statement, which is their defense. You put those two together and voila, you've got the pleadings.
But get this, it wasn't always a paper-pushing game. Way back when, people just argued their cases out loud in front of a judge. Over the centuries, those spoken arguments started being written down, and eventually, that evolved into the super-structured system of written documents we have today. It just makes everything more organized and fair.
Okay, now for the other side of the coin. If pleadings are about legal battles, then conveyancing documents are about peaceful agreements, specifically when you're talking about transferring property. This is the kind of paperwork you deal with when things are going right. It's not for a fight in court, it's all about creating a crystal clear record of a transaction. You know, like a sale deed when you buy a house, a lease agreement, or even a gift deed. These documents are the proof that a transfer actually happened.
And right here, this is the most crucial difference to remember. Pleadings are for a conflict, an adversarial fight that happens in court. Conveyancing is for a voluntary agreement made outside of court. One is for a fight, the other is for a deal. Simple as that. Okay, so we know what pleadings are. Now let's get into the rules of the game, because you can't just write whatever you want. To make sure everything is fair and clear, every single pleading has to follow 4 essential principles. These are the building blocks for any solid legal case. Here they are, the big 4. 1. State facts, not law. 2. Stick to only the material facts. 3. State the facts you need to prove, not the evidence you're going to use to prove them. And 4. Be concise and precise. Now let's break each one down. This first rule is so important. In a pleading, the lawyer's job is to just lay out the story. What happened, event by event. It's the judge's job, and only the judge's job, to take those facts and apply the correct law to them. Check out this example. It makes it perfectly clear. You wouldn't just write that the defendant was negligent, because that's a legal conclusion. No, instead, you have to state the facts that lead to that conclusion. They were speeding, they blew through a red light. You present the facts, and you let the court draw its own conclusion about negligence. Okay, so material facts. What are those? They're the absolutely essential pieces of your case. If you leave one out, your whole claim could just collapse. But, and this is a big but, if you add a bunch of irrelevant details, you just muddy the waters and confuse the issue. It's all about that perfect balance. This distinction is so vital, but it can feel a little tricky. Your pleading has to state what you're trying to prove, not how you're going to prove it. The how, the witness statements, the documents, the photos, all that stuff comes later, at the actual trial.
And yep, of course, the law has some fancy Latin terms for this. Facta probanda, those are the facts that need to be proved. They absolutely go in the pleading. Facta probantia, that's the evidence you use to prove those facts, and it stays out of the pleading. So, for example, you would plead that the defendant acted with malice, but you'd save the witness testimony about hearing him vow revenge for the trial.
And last but not least, clarity is king. Legal drafting isn't about using flowery language or big, complicated words. It's about being incredibly clear, direct, and impossible to misunderstand. As the source material puts it so well, a pleading isn't the place for fine writing. It's for the assertion of hard facts.
So let's wrap this all up. We started with the big idea: law exists to keep the peace. We learned it split into substantive law, the rules, and procedural law, how to play the game. Pleadings are the documents you use for a fight in court, while conveyancing is for agreements outside of court. And those 4 golden rules of pleading make sure every argument is built on a solid foundation of facts, relevance, and clarity.
And that brings us to a final thought. We've seen how much precision is required in court to keep things fair, but think about it. How does that same idea, the need for clear, factual, precise language, protect you in your own life? In things like a rental agreement or an employment contract? It's something to think about, right?